এটা ঠিক করেননি, বলেননি আপনি? My lord, this paper one mentioned for application. 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 Have you informed other side? I served to the notice, sir. So, my lord, can the part-heard matters be taken up first next week? Part-heard. Part-heard, because there are part-heard matters, my lord. My matter is at the top, but at part-heard it is 49. It is, let me see whether I will reach or not. So can it be taken up next week, my lord, at the top, my lord, before the criminal? I cannot. Because my, it was argued, my lord. Now again we have to argue de novo, my lord. Part-heard matter cannot be adjourned. Wait. Let me call first thereafter.
My lord, this for inclusion for a part-heard matter. This is praying for quashing of a 306 IPC. The main urgency is that the petitioner is a young individual.
Part-heard matter by whom?
By
myself.
your lordship himself.
Okay. He inform other side also.
I will intimate him. By
Lord, may be permitted to mention one matter. I apologize for mentioning this over the third time. Your Lordship would remember 2288 of 2022. It was mentioned for correction. The correction was sent over to the department, but thereafter also another mistake was error was apparent on the order. So, my Lord, I had mentioned it again. Your Lordship would remember thrice I'm mentioning this matter. The file is yet to come. Your 2288 of 2022.
What is the mistake?
The mistake is it's written as name of the petitioner Dibbayan Banerjee, whereas it will be name of the petitioner's advocate is Dibbayan Banerjee. And just for that particular mistake, I am also not able to apply for the certified copy, and one CRAN application is also pending.
Monday it will appear.
Wednesday.
Wednesday it will appear.
I'm deeply obliged, my lord.
Lord, may I be permitted to mention two applications, my lord, for inclusion in the list. It's a very small applications, my lord, which I have filed, my lord, because the CRR has become infructuous. There has been a FRT file.
Both.
Yes, my lord, two applications, my lord.
To be mentioned.
Yes, I'm grateful.
You also inform other side.
On notice I have mentioned.
Yes.
Number one.
Why it is appearing in the list? Something mistake, I think. This instance.
This matter has come up at our instance, my lord. I was not there on that date. My junior could not attend, my lord. And your lordship was pleased to hear my learned friend and might make the order clear. My lord, thereafter.
Have you made your
I have
argument?
prepared a written notes, my lord. My clerk has gone to stitch it. Just 2 minutes, my lord.
My lord, I need to see the written notes and reply on that, my lord. Because
reply? You have already submitted
yes,
your
I have,
case.
but what the other side contains, if they shows any judgment or anything, my lord,
We'll
I
throw
need
two judgments, my
I
lord.
need to respond to that, my lord. But the mentioning
So
was
go
done.
through it. I will pass over. I will take up this matter because I have already reserved this matter
My lord, I
for
need to
final
file my
judgment.
written notes also.
Only on request of the learned counsel,
My lord.
I have given opportunity to say uh, by way of written argument.
Yes.
My lord,
I will not allow by submission.
my lord, then allow me to file the written notes of argument. My lord, kindly, my lord, because I need to deal with the
You
judgments.
go
my lord.
through the written notes of argument first. If
Yes.
required,
Yes, yes, my lord.
I'll give you time.
Much obliged.
My lord, my lord will be hearing me today. My lord, just I'll,
Yes, I am keeping passover. In the meantime, serve
my
and
lord, I'll
file.
give a copy to her, my lord.
And if she want to
My lord, I'll
submit,
give a copy to her, my lord. Just let it be a short passover.
I am keeping passover. Now. You go through it, whether it is necessary, then I will
Yes, my lord.
allow you. In this way, we cannot adjourn the matter.
Yes, my lord, it was mentioned without
Difficult.
notice also, my lord.
You have to advance at least sub.
My lord,
My lord, this has been filed within time, my lord. It was dismissed for.
What is the main matter? This
My lord-
matter is pending since
My lord, I am ready with the
2017.
main matter, my lord.
You are ready.
Ready with the main matter, my lord.
What had happened, there were directions passed repeatedly for
By your
production of the case diary.
Hmm.
Well, there were earlier reports also that they could not trace out the case diary.
But
That
this,
was the difficulty on our behalf in production of the case diary. Now, well, there is
In
no,
this way, many cases I find the case diaries are not available, not traceable. Do you know the procedure of keeping case diary? How many case diary?
three.
Three. So why they are not
This is what-
collecting? Just simply you are saying
we pray for something, my lord. Your lordship kindly calls for an explanation or the appearance of
why should I ask for explanation? You should bring the case diary. Many occasions this court directed.
Yes, my lord, we have, but they are not handing over. They are saying it is misplaced. We are also unable to produce it before your lordship.
And my lord, the learned sessions judge is ordering on several dates after my lord has taken up this matter, when my lord was pleased to stay the matter, he's taking up the records, he's perusing the records. So my lord, at that the stage which was stayed, at that stage the case diary should have is in normal course, it should be available with the GR section over there, and it is being produced over there. Otherwise, how the learned session judge is passing orders? Even when the warrant was issued, thereafter, when my lord has given a stay, thereafter certain orders have been passed regularly. Then how is that court functioning if the case diary is not there?
And if case diary will not produce, how the trial court will continue?
But
proceeding?
this is if they cannot produce the case diary in high court, then how will the trial proceed over there?
If there is case diary not available, then you collect case diary from other department.
Other department, own department. Madam, this is Kolkata.
There should be a 3 case diary.
Should be, my lord. Ideally, should be.
So one case diary if misplaced, why you are not collecting other case diary from other department where it is lying? 2017 matter is pending,
Yes, my lord.
and several occasions this court pass order for bringing the case diary.
That's true.
What explanation required now? Bring the case diary.
They have repeatedly filed reports stating
So
that
what you are doing? What is the duty of the PP or APP? Simply they write a letter to the PP and you accepting. Should I call him personally?
Yes.
Law and order situation.
Yes, yes.
We all know that there is no
Well, let him
sufficient police officers.
does not happen in each and every case. So if they are not cooperating, well, the lordship may call for his personal appearance.
Let him explain.
come and explain.
At least
to the
you
lordship.
should suggest some way out.
My lord, all our ways are
You
not
should-
accepted. Lordship will kindly appreciate.
So I am recording your submission.
Yes.
Yes, my lord.
The police officer is not accepting your.
Restores the matter.
They are not cooperating, my lord. Time and
I will record that.
yes, my lord.
Let him explain. Come.
Yes, ma'am.
আসুন স্যার স্যার সামনে চলে আসুন blood extension of interim orders in both the matters.
What is the matter about?
Lord, a CBI inquiry, the case is pending before the learned.
You can hear it out. Main application.
Both the petitioners are the government employee. Allegation against the Prevention of Corruption Act along with the 420-471 charge sheet has already been submitted. Discharge application was turned out. Against them, they have come up with this honorable. Usually,
You
there
place your case.
kindly fix up any date on month of January.
Today is the date. You can proceed. Where is the problem? 2021 matter. Are you
Actually,
ready?
no, I was not because it was only interim order, so I thought
So
it will be.
only extending interim order.
No, Lordship will fix it peremptorily.
You have come before this court.
Lordship will
challenging
fix-
the discharge.
Lordship will fix it peremptorily any day. Next week, next Wednesday, next Friday, any day.
Yes, Lordship can fix it. And
ठीक है।
এর আগে তো আমরা বলছি করো না বাহ মার্চ অফিস
My lord, item number 6 and 7, my lord, I appear for the, my lord, petitioners. My lord, kindly, my lord, the affidavit of services.
But I have CD, but now I don't.
It's a POXO matter, my lord.
It is with me, my lord. I'll fix it tomorrow. I can fix it.
You do not have CD now.
Now, my lord, at this moment, my lord.
My lord, may
case.
Such a complainant, your lordship.
What is the matter about?
My lord, we are the directors, my lord. There was an agreement. MobiKwik is the company that is the accused, and we were executive directors, but not day to day. So, my lord, there was a case instituted, basically money recovery, my lord. Stay was granted, my lord, and time to time extended. This is the 5th application, my lord. The stay was till 29th November. It was filed within time, however, my lord.
200, section 200 CRPC.
Yes, my lord.
200 CRPC, your lordship.
406, 420, my lord, and 120.
Same 6, 16, 9. Cran 6.
Cran 5. State ke party করেছিল কিন্তু state appeal করে complaint. My lord, extended till my lord
16th.
16.
9.
Great.
Next day you prepare yourself. I will hear it out.
My lord, Mr. Milan Mukherjee is appearing in this matter. He will argue.
But ask him to
My lord.
prepare.
10 minutes, I am for the petitioner. This is the extension of interim order. I have filed. Very good. Interim order.
Have you received the copy?
Yes, yes, Milord Sahab.
Same date. 9th and 16th.
19th appears 16th.
Cran to dispose.
I am submitting on behalf of the
Yes.
opposite party number 2, my lord. Without trial, it cannot be decided. Unnecessary, if you
I will hear it out. This is only application. Today hearing not there, but it is appearing under heading application. Next day I will hear it.
Yes.
If you search the
Climb for the actually this is my restoration application 99 divisional application in 2018 it was dismissed.
99.
Yes, challenging the order and judgment and order of conviction my lord passed against this present petitioner under section 325 of the Indian Penal Code. My lord, he preferred an appeal before the before the London Sessions Court. Appeal was affirmed. Challenging that order, my lord, he has preferred this divisional application. The stay was granted, my lord. He was
Since 1999, why you have not surrendered?
No, sentence was suspended
How suspended?
by this honorable court.
You know, when the matter was dismissed, everything gone.
Yes, that is why, my lord, I have
Gone.
filed one restoration application, my
Why
lord.
you have not surrendered?
Thereafter, I was taken into custody. After dismissal 2018, matter was dismissed for default by this honorable court. Recently, in the month of August 25, my lord, I was taken into custody as the matter has dismissed for default. The warrant was issued by the learned court below. Now I am suffering. I am suffering the sentence. Sentence was, my lord, 1 year. Simple imprisonment.
Your restoration application will be dismissed.
My lord's desire last
Ordinate delay.
that I have
And surrender.
already I have taken into custody. I am suffering the sentence. Since month of August, I am suffering the sentence. I am in custody, my lord.
How I can condone the delay? 99.
99, it was dismissed for default in 2018. 2018, it was dismissed for default.
18. After that, now which year going?
That is true. 7 years.
7 years.
That is true, my lord. Kindly consider, kindly hear out the matter.
Serve
Your
out
lordship
the-
want,
serve-
your
serve-
lordship wanted
serve
to
out
hear
the
out the main matter, my lord.
What was the sentence?
325, 1 year.
What 1 year?
Yes.
Both trial court as well as appellate court affirm the order. What is the
That I have challenged.
what
Like
is the
ground, my lord. It is the prosecution case that with regard to construction of a shop room in joint property, there was some commotion and dispute between the son of the victim and the present petitioner. Now, the mother came. There was free fighting between the son of the victim and the present petitioner. Mother came to rescue him. Then the mother was assaulted by the present petitioner, her my lord, left leg was fractured. That was the prosecution case. My lord, with regard to that case, my lord, charge was framed under section 325-34 of the Indian Penal Code. Total 7 persons, my lord, 8 persons adduced as evidence. The son of the victim herself, one rickshaw puller, and my lord,
the copy of the condonation of delay to the private respondent.
the complainant, he was not made party to this, my lord.
You have to
Division.
fit party.
I shall, my lord.
I will hear both sides. What is the contention of the state with regard to the condonation of delay? So much delay, my lord. But leave it to me, this court. 7 years. Already he has arrested.
Already he is suffering, man, since month of August 2025.
So he's gonna be. He did not.
It was not within his knowledge. In 2018, it was dismissed. The old matter
Whenever
suddenly
matter
came and it was dismissed. My lord,
Party will definitely.
for
know
last
about
5
the-
months, he is in custody. He is suffering, man. Already he is suffering. He is a man of 66 and incident of 1985. At that time, he was only 26.
Okay, on merit you submit what is the case. Let us see. If you have merit, then
তাই তো বলছি। Kindly come to my lord, appellate court judgment, my lord.
yes.
Kindly come to page 11, the finding part.
11. Yes.
So the points I have agitated before the learned appellate court.
Page number internal page 11.
Internal page 5, running page 11.
Yes.
So for point number A, that the court below did not consider that the de facto complaint did not say any specifically that
Page number 11. You have said 11. Page number?
page internal page number 5. Yes. The finding part. Point number A, that the court below did not consider that the de facto complaint did not say any specifically that she was assaulted by the appellant. From the evidence adduced by the complainant.
Have you annexed the evidence?
No. This is only 2 courts judgment. Evidence is with me, my lord.
So she was not assaulted as per your contention. Yes. Next.
That my next point, that the prosecution did not produce the disinterested witness and the London magistrate wrongly relied upon the prosecution witness who are related to each other. That the court below wrongly came to a conclusion that the convict appellant caused fracture injury on the person of the de facto complainant. That the court below did not consider that injury on the person of the de facto complainant was caused by fall, which was admitted by the medical expert. Next, that the court below did not put vital questions to the accused persons at the time of examination under section 313 of the Code of Criminal Procedure. These are my grounds. Only these are my grounds. While adducing evidence.
Now show me the evidence.
Yes. This is the evidence of the complainant victim, PW2. She did not specifically say in her chip that the present appellant assaulted her.
Yes, where is he?
I have not marked, my lord. Since it is a certified copy, I have not marked. That part is there.
What
That part, the chip part.
What is the observation of the appellate court on this ground?
Lord, now kindly come to inner page 8.
Yes, 8.
Second paragraph. I have gone through the evidence of PW2, who is none else but the de facto complainant. It is true that she did not specifically state that she was assaulted by Anwar, the present petitioner, with iron rod for which she sustained fracture injury during
Her examination.
examination in chief. She, however, stated that her statement was recorded by the Daroga Babu and she put her LTI, and she added further that said statement was recorded into writing by Daroga Babu as per dictation. In her cross-examination, she specifically stated that Anwar broke down her left leg. That was mentioned while lodging the complaint before the police station. But in court, she did not specify the name of the
Your
petitioner.
cross-examination, you have taken that. Who has assaulted, she has stated. That is sufficient.
Because the prosecution case that Anwar along with others assaulted her.
Examination chief, he did not disclose who has assaulted. Now you have cross-examined. Who assaulted? She stated the name of the assailant. So you yourself bring the evidence.
But she stated Anwar along with others. Others have been acquitted by the learned magistrate.
Broken down our left leg.
Yes.
What require further? What require in cross-examination?
Case was started against 4 accused persons.
Now next point.
Yes. It is therefore clear that specifically mentioned the name of the appellant as the person who caused fracture injury on her leg. It is true that she did not say specifically that she was assaulted with an iron rod by Anwar.
No problem.
We must keep it in mind that PW2 is an illiterate lady who deposed before the court after a lapse of 3 years. The court is to consider the evidence of PW2 as a whole, coupled with complaint which was reduced in writing as per her direction. The said complaint was duly proved in course of trial, and on perusal of the same, it is seen that she specifically mentioned this appellant as the person who caused fracture injury on her left leg due to assault with iron rod. That was the observation of the learned judge. Next, in view of the said position, that this court is of the clear opinion that the said plea as raised by the learned lawyer for the appellant cannot be accepted. Now the next issue which I canvass before the learned judge. The learned lawyer appearing for the appellant also challenged the prosecution case on the ground that the injury on the person of PW2 was due to fall. For this, the attention of the court was drawn to the cross-examination of PW2, wherein suggestion was put to the effect that she sustained fracture due to fall. The said suggestion was denied by the de facto complainant. The attention of the court was also drawn to the evidence of the medical experts who has been examined as PW7 and PW8. It is true that medical experts admitted in their cross-examination that such fracture injury can be caused due to fall on hard and blunt substance.
That is only a suggestion from your side.
Before accepting the defense case, it is the duty of the court to see whether the defense has been also to prove their case that the injury on the person of the PW2 was caused due to fall. Mere putting of a suggestion is not sufficient for court to come to the conclusion that such injury was caused by fall when the suggested suggestion has been denied by PW2. Nowhere from the evidence on record it can be seen that PW2 sustained such injury after fall. On the contrary, PW2 in her evidence stated that after she was assaulted by the accused persons for which she fell down. The evidence of PW3, that is son of the victim, is also of great importance as he gave the vivid description of the occurrence. It is clear from his evidence that he totally corroborated the prosecution case that trouble started when her mother came to rescue him. This witness specially mentioned the name of Anwar, who assaulted his mother with iron rod on her left leg, for which she sustained fracture injury. The said witness has been cross-examined at length by the defense, but on perusal of his entire cross-examination, it is clear that he faced the defense on short with credit. Next, learned lawyer appearing for the appellant challenged the evidence of PW4 on the ground that the said witness did not say specifically that Anwar assaulted PW2, that is Johura Khatun, with an iron rod. On perusal of the entire evidence of PW4, it is also seen that Johura tried to rescue her son when she was assaulted by the accused persons, for which she received fracture injury. It is therefore clear from the evidence of PW4 that he also implicated Anwar, who was one of the accused before the court below. There is no dispute that injured, that is PW2, received fracture injury on a left leg. The said fact has been proved beyond reasonable doubt by the medical experts who deposed as PW7 and PW8. On perusal of the evidence of these two witnesses, it is crystal clear that the injured Johura sustained fracture injury for which she was treated at Uluberia Hospital. The report of the medical experts, which has been marked as Exhibit 3, also goes to show that the patient, that is Johura Khatun, mentioned the name of Anwar as her assailant with an iron rod. It is clear from the said medical report that she was treated at about 5:30 p.m. on that day incident, and she specifically mentioned the name of Anwar as her assailant. It is true that mentioning name of the assailant before the doctor will not be sufficient for a court to come to a conclusion that Anwar was responsible for the injury, but the said report is of great importance as the patient mentioned the name of her assailant immediately after the incident to the medical expert. The said piece of evidence corroborates the prosecution case that the appellant caused fracture injury on the left leg of the victim with iron rod. The order of the learned magistrate was also challenged on the ground that the learned magistrate did not put specific question during examination under section 313 of the Code of Criminal Procedure. I have gone through the contents of 313 of the Code of Criminal Procedure. With respect to the appellant, it is seen that the learned magistrate put specific question to the effect that the appellant caused fracture injury on the left leg of the victim with iron rod. In my opinion, the accused appellant was not prejudiced by not putting other questions by the learned magistrate. I am pausing. I have handed over the 313. Only one question was put to him. Only one question. Kindly have a look to 313, my lord.
Please read it Bengali language.
Yes, it is in Bengali.
Please read it.
May I? Yes, this one.
Please read it. Question number 1 and 2.
সাক্ষ্য প্রকাশ সবার সপক্ষে সপক্ষে সাক্ষ্য প্রমাণ শুনেছেন তো? হ্যাঁ স্যার, সাক্ষীর সময় সাক্ষী দাখিলিখিত এক্সিবিট সমূহ সৃষ্টি প্রকাশ যে গত ইংরাজি 27/2/85 তারিখে এই সময়ে 2 নম্বর সাক্ষী জহুরা খাতুনের বাম পায়ে দিয়ে রড দিয়ে মেরে ওর পা ভেঙেছেন, এ সম্পর্কে কি বলবেন? মারিনি। Only this was the only question.
That is sufficient.
How the incident took place?
What
So for
remains?
other questions, how the incident took place? Because the against
Not
4
required.
persons complaint was registered. Charge was framed against 4.
Whether you have
Only
assaulted
this
or
man
not,
was, my lord,
that is
convicted.
sufficient circumstances for only assault, and she suffered injury in her leg. That is corroborated.
So for other circumstances, my lord, kindly consider how and my lord, on which manner the incident started to take place.
Next. ওই পাস ওভারটা একটু দিন। আচ্ছা আমি দিচ্ছি। Yes, have you gone through it?
Yes, my lord, give me some time, my lord.
So you
The
file your
written-
written note of argument.
My lord, I am submitting my written notes.
Written notes of argument filed by the
My lord, 2 weeks.
by the petitioner is
Opposite
taken
party.
on record.
I am for the petitioner, my lord. I am led by Mr. Bhattacharya, my lord. My lord, a classic case of abuse of process, my lord. A case, my lord, civil.
I have already heard both sides.
I am deeply obliged. Today is fixed for my.
Only you give me an answer with regard to the paragraph 5 and 6 of the written complaint.
My lord, today is fixed for my composite reply, my lord. I am deeply
What
obliged,
is
my lord.
composite reply? I do not require any composite reply.
But
I only want to clarify about the paragraph 5 and 6.
I am deeply obliged. I'll take your lordship to that, my lord. But since, my lord, on the last occasion, my lord, they had relied, my lord, on a set of judgments, my lord. 3 judgments, my lord, were relied upon by them, my lord. So, my
That
lord,
is relating to 5 and 6 itself.
so, my lord, 420, 406, my lord, relating, my lord, pertaining to those specific paragraphs, my lord, I will make brief submissions, my lord, on facts, my lord, as well as on law, my lord. I am led by Mr. Bhattacharya, my lord.
This can't happen, my lord.
I have a right to reply, my lord.
Only on
I am replying pertaining to that.
Please come to paragraph 5 and 6.
I am deeply obliged.
Regarding 406, 420, I have some different view. But after hearing the paragraph 5 on the
I am deeply
submission,
obliged, my lord. I will confine my reply to that, my lord. I am led by Mr. Bhattacharya, my lord. I will confine my reply to
I have already heard you in length.
I am led by Mr. Bhattacharya, my lord.
Yes. Paragraph not 15 and 16, not 5 and 6, but paragraph number 15 and 16. It is admitted facts that 2 treasures were purchased by you.
Right, my lord.
And those treasures were under hypothecation.
Absolutely.
Now you come to the paragraph 15 and 16.
The asset was not found.
Yes.
Your lordship is right. My lord.
The asset was removed from the palace.
Right, I have read, my lord.
When they visited.
I am obliged, my lord. I will have an additional prayer in the matter. At the very outset, I wanted to make it, my lord. But at the end, I will make that prayer, my lord, before your lordship. Only see 3 paragraphs, nothing else, my lord. Come, please, come to, my lord, page 25.
25 of?
My lord, this only, my lord, this complaint. Inner page will be 3.
No, only I only want to clarify.
Right, my lord. It's evident from the complaint.
Paragraph number.
My lord, page 25. Towards the bottom, my lord, asset details, second last line. Page 25.
There is no.
But that's the part of the complaint, my lord.
25, yes.
My lord, second last paragraph, my lord, asset details.
Asset details.
2 dredgers are mobilized. Now kindly comes to my lord, next page 27, para 13. The total amount, has your lordship got it, my lord? Para 13, page 27.
Yes.
The total amount payable, my lord has got it. Against these contracts of ADMS was rupees 85 crore such and such. The total amount paid by such and such 2 crore 95 lakhs such and such from its own source and rupees 47 crore 85 lakh 90,181 adjusted from sale of dredgers. So where is the question of, my lord, misappropriation of assets? Your lordship has rightly pointed out this was a case of loan and hypothecation. What was hypothecated, my lord? 2 dredgers. What have they done? They have sold off. They have adjusted that amount.
Now they are searching dredgers.
Now they are searching that, they will never find it. Now sees, my lord, the beauty. My lord, my additional prayer will be, my lord, this is a matter where your lordship will kindly impose token cost. My lord, the FI, my lord, this is a complaint filed, cognizance taken, process issued. 4240634. I argued on that. I wanted to keep the matter very simple. My lord, that I just tell your lordship, my lord, the agreement, according to them, the representation was, my lord, in 2016, if I'm not wrong. 2012. My lord, page 24, para 3, kindly sees. Sometimes in or around.
Yes. July 2012.
I'm mobilized. Now, my lord, sees the filing of the complaint, the date of cognizance, 2017, my lord. At the end, your lordship will have the affidavit also. In the complaint also, your lordship will have the date.
Case was also filed in the year 2017.
2017. Now, my lord, admitted part payment. Admitted, my lord.
Sale of 2 dredgers.
I'm mobilized. Now they are saying, look, I don't find the assets. You have sold it off. My lord, there is no charge of mischief. That was argued before your lordship that, look, if there is no 420, there is mischief.
Now I understood. Yes. Last time you have submitted paragraph 15 and 16.
Yes, my lord. Read with paragraph 13.
And
asset was not found its supposed location despite agreement.
Yes, my lord. Then my lordship would kindly take my affidavit in opposition.
No, what?
It's evident from the complaint.
My lord, I have made out a case over there. My lord, I have made
out your case under section 425.
Yes, my lord, I am just doing this. I'm
Four,
doing this.
406
My
and
lord, I have
420 already gone.
Absolutely. And no cognizance under 427.
You argued only on the section 425. Mischief.
Mischief.
What is the mischief now?
My contention was this, my lord, the sale of dredgers, what has been showed, that was a book adjustment.
But is their complaint? Where is book adjustment? Well, I will not trouble your lordship further. I'm deeply obliged.
My lord, only one thing, your lord, since your lordship has given me
Mr. Kundolia is appearing for. Problem is 3:30 always, 3:30 always in Friday. It is the main. But the next Friday, not at 2:30. But the inter-reporter will be at 2 p.m.
Any day, 2 p.m.
This case is relating to the Supreme Court. Some cases pending. I think what is your submission?
I have submission from the FIR.
That is not related with the Supreme Court case.
Yes.
But other cases has been already stayed.
Next Friday, next Friday at 2 p.m.
Mr. Mukherjee has submitted in length.
But there are two matters in one matter, Mr. Mukherjee. I was assisting him.
This is not that matter.
No,
That
these
is
two matters. Mr. Basu is mentioning two matters.
next Friday at 2 p.m. Friday extend the interim order till that. Item number 39 and 40. Today expiring.
Yes. What about next one? What 16? Next Friday.
Today expiring.
কোনো নোট লাগবে তোর মনে হচ্ছে মামলা no right now is it
44.
let us ensure that
44,
we are
45,
in order.
But
Just
if I am fixing, but you must be present.
Yes, he was present. Somehow this matter took some time. 45, 46 and 47.
45 and 46.
45 and 46. I will kindly keep saying
আমাদের আইটেম নাম্বার কত 16
9 January fixed আছে কোনো?
230 থাকুক তো সুবিধা। ওই 230 হ্যাঁ দেখি মাইনর
দেখে নিয়ে কোনো অন্য
sweet oh my god
9th January.
হ্যাঁ I'll have a date for sure
now the 16th of June.
for someone else
It is very difficult to
I
get
am
date before your lordship.
somewhere else.
What can I do?
On account of popularity.
No popularity. What
See,
popularity?
this side.
all of us are here
नहीं 230. 230 on 9th.
Most and one interim order may continue. till
Interim order till 16th.
16th. Most of
Total 5 and 6.
সেটা তো আমার পরেরটা
Appear on
না
9.
আগে হিয়ারিং এ কল হবে তারপর যা কর and today expiring and that kind of matter I think it should interim order should be until further orders.
There is 16th. Record to
এবার করো আমার পর যত ইচ্ছে Your Lordship remembers staring one of its kinds matters.
That type of case I have dealt earlier. That Audi.
Audi, yes, true. That's a
This-
reported
this
judgment.
is some technical issues are involved.
Most importantly, we didn't have a technical issue.
Yeah.
This was what we were selling. This steering wheel is not supposed to come back at all. It's the power steering which goes only one way. It does not come back. These features are not there in these kind of cars. The high-end cars have different kind of features of Maruti itself, which is sold by
Routers
Nexa.
are already annexed with the petition.
Which one?
In this,
Yes. And they have admitted, my lord, that they are working, they have driven the car for 5,000 kilometers. 5,000 though.
No test drive taken.
No test drive taken, driven for 5,000 kilometers,
Yes,
three
yes.
services, 3 free services done. After that,
Finding in the
Maharaj comes and says that the steering is not working because it does not roll back to its original position.
And it's written that we are happy with it.
matter will appear on 16th January.
16.
Only that.
On 19 expiring, 19 your lordship has to discuss these other matters. That
No,
is
no,
the-
I will extend on that day.
No, that day your lordship.
No, 19, if time will not allow, I will pass order
My understanding.
before rising.
My other, sir, I will not be there on 19. That is
Your junior will be there.
very well, my lord.
My lord, for item number, my lord, only one index, my lord. Item number 2, my lord, while lordship was passing your lordship's order, my lord. My lord, written notes on behalf of the opposite party has been filed today, my lord. My lord, it probably, my lord, subject to your lordship's question, it became.
My lord, it might have gone as written notes of the petitioner. Petitioner is Enforcement Directorate. My lord, we will file.
The petitioner.
Yes, so it will be on behalf of the opposite party.
একটা correction করে দেবে. Written notes